Act defines what matrimonial property is. It says that it is the family home, the matrimonial home, household goods, and any property that's jointly owned and that is acquired during the marriage. I'll repeat because it is important. The matrimonial home, household goods, and then any property that's jointly held by the couple and acquired during the marriage. Then it also defines separate property. Of separate property, it says it's any property that does not qualify to be matrimonial property. And that property then belongs to the person in whose name it is registered, except to the extent that the other person, and of course I'm talking about a couple, even though divorced, except to the extent that the other person is able to prove that they have contributed to that property. Very important distinction, because when we talk about matrimonial property, we seem to refer loosely to every property that is acquired during the marriage.
Correct.
But the Parliament, in its wisdom, found it necessary to separate between matrimonial property and separate property. So any property that is not the matrimonial home, that is not household goods, that is not jointly owned by the couple and acquired during the marriage, falls in the category of separate property. The reason why I seek to distinguish the two and why it is important to distinguish them is because there is protections afforded to matrimonial property that are not afforded to separate property. So the law says that where the matrimonial property is concerned, there is a presumption that, and it's a rebuttable presumption, that if it is held in one party's name, it is so held in trust for the other. A rebuttable presumption. The law also says that you cannot evict somebody from the matrimonial home without a court order. The law says you also cannot alienate, meaning you cannot change ownership of a matrimonial property without a court order, without the consent of the other person, meaning you cannot mortgage, you cannot transfer it to a third party. You cannot deal with it in any permanent way without involving the other person. So it may well be registered in your name, right? The matrimonial home, but you have no right to mortgage it, to transfer it, or to alienate it in any other, permanent form without the consent of your spouse. Okay, and that is very important because banks have previously mortgaged properties, matrimonial homes, without seeking the consent of the spouse. So the consent of the spouse is key, is critical, and if it is not sought, that mortgage can be nullified by the court. So that is important. Then the separate property, the law says, if the property is in the category of separate property, the marriage has no effect on it. You can deal with it as you wish.
So it sounds like everybody gets their equal share.
Yes.
And
you would think.
Yeah.
You would think.
Oh, no.
It's not quite the same.
Oh no.
So let me finish telling you about the laws, because there is also polygamy. Remember, we talked about one of the types of marriage recognized in Kenya as being customary and Islamic. And with respect to polygamous unions, the Matrimonial Property Act provides that in division of property, the husband and the first wife will share the property that was acquired before the second wife came. You see what I mean? So you need to know when the second wife came. Correct. Because what is acquired in that time before the second wife comes, it's only entitled to be shared to the husband and the first wife. What is acquired from the time that the second wife came, of course, is subject to contribution. Okay.
Correct.
What is acquired after the second wife comes, then will be shared by the first wife, husband, and second wife. Then if the man is still interested in marrying some more, then you need to know when the third wife comes, because then the third wife will be entitled to a share of the property together with the others from the time that she came in. But I should hastily add that the law provides that it is possible for a husband and wife, even in a polygamous setting, to get into a prenuptial agreement that provides that they can hold certain property without the participation of the other wives. You see? Yeah, so there is also room there.
Very comprehensive.
Yes,
Yeah.
okay,
Like this.
okay.
Mhm.
I'm glad. So what has happened in our courts? You might wish to know. Okay, so remember our courts now as at 2014, 2013, the mindset is show financial contribution. Then this act kicks in, and so some courts took it very well, and non-financial contribution was recognized. But unfortunately, the discretion lies of how much to award lies on the individual judge or magistrate in each case. And of course, no two cases are ever the same. Okay, but the place where the greatest concern has been is where property is jointly registered. And I should actually take it a little back and tell you that the Matrimonial Property Act says that where property is jointly registered between spouses or former spouses, by the way, they should be former spouses, because by this time, by the time the Matrimonial Property Act is kicking in, you have to have been divorced. Property is not divorced, it is not dissolved if you're not divorced. Okay? This is against public policy to divide property where the marriage is still in existence. Okay, so in the case of property that's jointly held, the law says that there is a rebuttable presumption that both owners, both spouses, have equal beneficial interests. So remember, both your names are on the title.
Correct.
So sometimes spouses are able to agree to divide the properties equally or which way. But many times they have gone to court, and unfortunately, the courts have held very differently. There are some courts that have even awarded 10% to one spouse, others 20%, others 30%. So in a way, the more things change, the more they remain the same. But we are hoping that as the time goes, courts will recognize that once you decide to register a property jointly with your spouse, you surely must know what you want. Okay, and therefore that a division, it should follow that they should be entitled to 50% each, unless they are extenuating circumstances. Like, for example, this person held in trust for you, or something of the sort. But in other circumstances, I don't quite understand why they hold otherwise. But it is been the case that you don't know what the outcome is going to be until it is given.
So how is a non-financial contribution determined by the court?
Okay, the court looks at the evidence provided. So if I was representing a party who seeks for the court to recognize her non-financial or his non-financial contribution, I would show that they have provided companionship to the other spouse. And that's not difficult to show, because you need to talk about the times you're together, perhaps before conflict set in. I would show about childbirth, where there has been childbirth. I would show about childcare. I would show about domestic work. Okay. I would show working in a farm, for example, or stuff like that. Anything that's a contribution to the family that is not financial. Now, the challenge is that there is no weighing scale as such. So it's completely left to the discretion of the judge. And some judges recognize how important non-financial contribution is to a family. Because many of us actually say it is easier to go to work than to sit at home and do all the chores. Very exhausting, number one, and nobody seems to appreciate. Because you clean a floor, in a few minutes the floor is dirty. You cook food, in a few minutes it's gone. You clean the dishes, in a few minutes they are dirty. You wash clothes. It's so fatiguing. And even just the primary caring, of children. Even giving birth, even bringing up children, all those, the emotional support of family and what have you, it is actually impossible to quantify.
Correct.
So at the very least, you would expect that courts would give a 50% contribution to a person who has done that, okay? But for the person to get 10% perhaps speaks to a lack of awareness on the person sitting also to give the decision of the non-financial contribution and the extent of it, because honestly it's easier to go to work than to do all those other things. But there you are, we still have a challenge, but then again we are a developing nation in that regard. Okay, Rome was not built in a day. This Rome started being built in 2014 when we started implementing the Matrimonial Property Act. So we haven't lost hope. We're speaking to one another actually in some of those forums that we have between the bar and bench, between the lawyers and judges. We discuss the decisions that come from the courts and how they can be very conflicting. You know, sometimes when you have one judge giving 10% for non-financial contribution and another one giving, 50%. So we will all get there eventually, but it is certainly slower than we expected it to be. Yes. Yeah.
And Judy, within this process, what happens to debts and gifts given, for example?
Interesting. So if you gift your spouse during your marriage, at the point of division, the law assumes there's a rebuttable presumption that the gift was absolute. Okay? You'd have to show reason. You, the giver, if you're still claiming the gift, you'd have to show that it was not intended to be absolute. Okay? Yes. So about debts, the law says if the property that you are seeking to share has a debt, then you're both responsible for that debt. Okay? So that in case law, the courts have said you can only share the net of the property after the debt is paid.
Yes,
Does it make sense?
Yes,
exactly.
Absolutely.
So if you go to court today to seek to divide property, and in respect of one of them there's a mortgage, then the court will say either you sell the property, and you can sell by private treaty or with the consent of the bank, and you pay off the debt and share the balance, or you wait until the debt is paid, and then whatever is left of the property you share between yourselves.
And so the responsibility of the debt is upon both.
Indeed.
Both parties.
Indeed.
Okay.
Indeed. So from the point that the marriage breaks down, it counts who was actually paying the debt.
Yes.
Because you see, you are no longer providing to each other the non-financial contribution. Presumably, there is no companionship anymore. Everybody is leading their lives.
Correct.
So if I'm the one who is paying the mortgage, from the time that the marriage breaks down, then I should expect that I'll be able to recoup the mortgage installments that I have paid once the property is sold.
Correct.
And then we will share the net.
The net.
Once the property is sold.
Okay.
Otherwise, nobody will pay the mortgage. You see, if this person is thinking, I pay the mortgage, and then she benefits, or he benefits, nobody will pay the mortgage.
Sure.
Yeah.
When I was asking about gifts, I actually was referencing gifts that come from outside into the marriage. So what happens to that? Because you spoke to the gifts from spouse to spouse. And amazing, because that was going to be another question. But what about gifts that come from the outside into the marriage?
Well, that's a very good question. Indeed, we should have started there, because property that is gifted to you, property that is inherited by you, remains separate property. If you inherit property, if you get a gift of property to you, it remains separate property. But if the other spouse contributes to the improvement of that property, of that separate property, then they're entitled to a share of that property to the extent of their improvement. You see, so that talk about many couples up country, they will marry and they will live in the boy's family land,
correct,
for example. So you could argue that land is inherited by the boy, it's therefore gifted to the boy,
correct,
isn't it? So the girl should not have a claim technically. But if she has contributed to the improvement of that land by building a house, by planting cash crops, perennial crops as they are called, then she's entitled to a share to the extent of that contribution, apart from the fact that it is also their matrimonial home.
What happens when one spouse dies? Can the other spouse still make a claim?
So we have posthumous division of matrimonial property. And posthumous is where one spouse is living and the other one is dead. Because you see, marriage is also dissolved by death, if not by a court of law. And this living spouse can determine to seek for division of their property from the estate of the deceased person. Where we see it especially happening is where this person that has died has many other people claiming the property from his estate. So this spouse decides, let me take my 50% share and I can leave the others, all those other people that he had who are his beneficiaries, to share in his remaining 50%. So there is indeed posthumous division of matrimonial property. Yeah.